This was one of the first issues that attracted our attention. The pattern that we see is typically the same. Schools they locate and advertise to unsophisticated young people, tell them that they can get a real career if they enroll, and the students wind up a couple of years later working in the same types of minimum wage jobs they were doing before, only with tens of thousands of dollars in loans to pay off. The students don't realize until well after they've left school that they were lied to. These schools' sole function is to continue receiving federal money as long as they can continue convincing students to sign on the dotted line, which is honestly not that hard. It doesn't matter what happens to the students when they finish school. There's no accountability and there's no justice coming at any point in the process. The dangers posed by con artists like those in the for-profit college industry are not new in our economy. There are effective mechanisms for combating these practices in most sectors of the economy. However, for decades, the legal regime governing federal student loans has protected these schools from having to meet even a minimal standard of accountability, and it has denied students any opportunity for relief, even in the worst of cases, even when it is widely acknowledged that their rights have been violated. This rulemaking presents an opportunity to change this trend by finally providing students the right to start over, or some remedy. In addition to laying the groundwork for a fair approach to student claims going forward, this may also be our last opportunity to do what we can to redress some of the wrongs of the past. However, in order to accomplish these goals, the negotiators must take care to create a process that is accessible to students and that broadly confronts the harms that students have suffered. Here are some of the issues that should be included in the negotiations to ensure that this proceeding is effective. First, the process should address past as well as future wrongs. The negotiators must ensure that the process allows students to assert defenses to repayment not only of direct loans, but all other types of federal student loans, including FFDL and consolidation loans. It would be unfair for students who suffered the exact same harm to be treated differently simply because one student borrowed prior to 2010 under the old FFEL regime while another borrowed under the new regime. The department has consistently maintained that students have the same rights to assert defenses to repayment of FFEL and direct loans, and the time has come to clarify those rights and make them applicable to all federal student loans. The negotiators should further clarify that state law statutes of limitations do not bar students from asserting defenses to repayment. Thousands of students would have asserted defenses over the last few decades if a meaningful process had been available to them. It would be unacceptable to deny relief to all of those students because of a statute of limitations when there was no way for them to assert their defense at the time of their injuries. The next point I want to get to is that the negotiators must consider whether to allow students, should consider implementing a uniform standard in addition to using state law as a basis for defenses to repayment. The department's own regulations regarding misrepresentations to students, as well as the FTC Act and the FTC's regulations, and the practice of the FTC and the CFPB in pursuing predatory businesses and protecting consumers, could serve as appropriate guides to how to formulate a standard for when students can assert defenses to repayment of their federal loans. This standard would relieve the administrative burden on the department of having to review state law claims from students around the country under the laws of 50 different states, and it would also ensure a measure of basic fairness, because it would be inequitable to deny relief to students under a federal program simply because they live in a state with weaker consumer protection laws when the department has full authority to manage the student loan program. The last thing I'm going to touch on, there's a lot of points, but I can't get to all of them, is that this process should be tailored to provide as much relief as possible to eligible students, which means going beyond simply discharging the loans. The negotiators should consider what steps are within their power to make students whole beyond simply discharging their loans. Most of the students that we've worked with, most of the students that we've talked to my surprise, rather than swearing off higher education for good, which is what I may have done if I had had the experiences they had, They simply want the same thing they've always wanted, the chance to open up new opportunities in their lives through education. In order to allow them this chance to start over, the department should, at a minimum, reinstate their eligibility to receive Pell Grants. Further, the negotiators should consider what steps are within the department's power to compensate students for the loss of other benefits that may be necessary for them to pursue education, such as state benefits, veterans assistance, and things along those lines. The existing regulations already clarify that that the department has the authority to grant further relief as it deems necessary. So it's important to think of what steps can be taken to make students whole as much as possible. Thank you very much.